So, grand jury. What is a grand jury? It's really simple. And first you need to know it's only for federal government. There are state grand juries, but it's up to the state. The Supreme Court has never selectively incorporated this part of the Fifth Amendment, meaning they haven't used the 14th Amendment's no state shall deny its due process clause to apply grand juries to the states. So only to the federal government, and not in times of military trials and things like that. You heard that in the amendment. This only applies to federal crimes for infamous crimes, meaning felonies. That's how the Supreme Court has defined this. So if you commit a felony and it's a federal crime, you get a grand jury. So what the hey is a grand jury? A grand jury comes before you're indicted, before you're arrested. In a sense, it's supposed to protect you against overzealous prosecutors. If you're my neighbor, and let's say you're, 18, 19, you party all the time, you're playing your kid music, and you're doing the tweaking or the twerking or whatever that is, and I'm a cranky old man, I could really mess with you if I didn't have to go to a grand jury. I could just arrest you for murder. Yeah, that would screw you, right? You'd have to get a lawyer, your family and friends would be looking at you cross-eyed, your girlfriend would leave you, or your boyfriend would leave you, no one would love you. You'd be living in a van down by the side of the river. It's a Chris Farley joke. But needless to say, you do need to go to a grand jury to avoid that. And the grand jury is basically like a regular jury. They listen to the prosecutor and the evidence. Now, you don't get to bring your defense lawyer in there, and certain rules apply that are much more broad. There's no exclusionary rule in a grand jury. So if you found evidence illegally, it's all good, baby. But basically, it's just to make sure that if I'm going to go forward, that there's some type of reasonable suspicion, there's some type of evidence, there's enough evidence for a trial. I'm not just getting you because I don't like the twerking. Is it the tweaking or the twerking? So that's what a grand jury is. Now, most states don't do grand juries. Most states have what's called preliminary hearings. You've probably seen this on Law & Order, where you present it to a judge. So, a little bit different for the state. Giddy up, here we go. I think I'm going to do Jeopardy! Double Jeopardy! Alright, you've seen the movie Double Jeopardy, then you could just fast forward this part. But Double Jeopardy basically means that I get one swing at the bat with you in terms of a trial. If I arrest you for murder, and then you are convicted or acquitted, that's it. I've had my shot. I either got you or I didn't get you. So in its very most basic form, it's just to protect you against multiple prosecutions. Now, if it's a mistrial, it depends on who calls the mistrial. But generally, mistrials can generally lead to new trials unless it's prosecutorial, misconduct, like the prosecutor is cheating or lying and there's a mistrial, then the prosecutor doesn't get another chance. There's also some pretty strict rules in terms of that I can't charge you. Let's say you murder 3 people in a crime, right? Why don't I just charge you for murder once? If you get off, I'll just charge you for murder again for the second person. Then if you get off again, then I'll charge you for the third murder. 3 different murders, 3 different trials. No. I think it's called the Blockberger rule after a famous Supreme Court case that says if the crimes are tied, you have to try them at once. You can't have multiple opportunities to try those crimes. Now, if I rob a bank, and then a few days later I decide that I'm going to, steal a meth van, then those are 2 different crimes. They can have 2 different trials. You shouldn't rob banks and you shouldn't rob meth vans, I'm just saying. All right, let's take a look at the next part, which is one of my most favorites. All right, you have the right to remain silent. And of course, this is probably the most famous part of the Fifth Amendment, talking about the right not to be a witness against yourself. And certainly this traces back, like much of the Bill of Rights, to the Magna Carta, and I think back to Oliver Cromwell, and the concept of not having, to be self-incriminatory against yourself, where that comes from. But the very basic concept is certainly at a trial, you do not have to take a stand. The government has something to prove. You do not have to help them. You don't have to be like, I'll help. You think I did it? Here, I'll go. Let me. What do you want? What do you want to know? No, you certainly don't have to do that. And technically, you don't have to answer any question the police gives you.